The Attorney General told the Senate the Miscellaneous Provisions Trial by Judge Alone Bill 2017 proposes to allow an accused person to choose to have his case heard before a jury or by a judge alone. The AG said from 2011 to 2016, jury trials took an average of 15 days, with the minimum wage average for jurors costing $1.5 million.
And you take an average of the costs that lawyers charge, junior lawyers at somewhere around $2,500 per hour, senior lawyers at close to $4,000 per hour, average it out, let's take $2,500 per hour. The man-hour cost translated to legal fees is $260,625,000.
The AG quoted the Chief Justice's remarks at the 2016-2017 law term opening that the jury system is not working and that there is no right to a jury trial. Questioning why the AG spoke of the legal fees, independent senator and senior counsel Sophia Choate referred to the Constitution.
Members of the public should be able to play a part in civic and in civil life. And the way in which the average person is entitled or is permitted by law to do that is by performing jury service.
Opposition Senator Gerald Ramdeen said the AG was asking the Senate to amend Section 7 of an act after it was struck down by the High Court twice as being unconstitutional.
It is unconstitutional because it takes the liberty of the subject who is tried before the High Court and has to be sentenced under the Offences Against the Persons Act and places it in the hands of the executive.
The AG said the bill does not require a 3/5 majority. Jewel Brown, TV6 News.
6:23 in Trinidad and Tobago. Well, we've heard from both the opponent, Gerald Ramdeen, and the proponent, the Attorney General, who looks younger with every passing day, I have to say. Clearly very... Oh, got a little peacock, man. No, what's the big deal with that? Anyway, let's get another perspective from another attorney at law. I don't know if he's getting younger by the day, but we'll find out from Martin George. The last time we were speaking with him was on election night in Tobago, the THA elections. Mr. George, good to have you with us once again.
Good morning, Trinidad and Tobago.
Your perspective on this, are you an advocate of what the Attorney General and the government they are proposing?
Well, I'll start off by saying this for you. I am certainly very much in favor of many of the legislative changes that the current Attorney General has tried to put in place, because I think I sense a genuine attempt to try to expedite things, to try to make the system work a little better.
Is that compromising justice?
Well, in this particular one, I am not in favor of it, because I'll tell you why. When you come to the question of trial by jury, it is fundamental to our current justice system. And it makes a world of difference for you, for someone to think that, look, it's the ordinary man in the street whom I can relate to, who is judging me on this issue, as opposed to a judge who may be far removed from the day-to-day realities. And I'll give you a simple example for you. Years ago, we had a matter where a man from Beetham had been beaten by the police in custody, and lots of atrocities had been committed against him. And prior to the evidence being completed, the judge, who was someone who lived in one of the gated communities, and he made the comment. He said, listen, he has had experience with going to the police station to make reports, and the police have never treated him that way. So he finds it hard to believe that police officers could beat a man so mercilessly. And and my point to him was, Judge, that's exactly why you have to hear the experiences of what the people on the street, what they go through. Look at this situation that was highlighted, I think, on TV6 a couple nights ago, with the man trying to throw away the bottle.
And spend
Look
10
at
days in
that
jail.
abuse of police authority. Now, a judge who is sitting there, you're all in your robes, you have your driver, your chauffeur, you have your big J on your car. No police officer is going to approach you and treat you that way. But the point is, these are experiences that the ordinary persons encounter very regularly. So therefore, they bring a very unique perspective to the criminal justice system that a judge can never have.
But, Mr. Job, doesn't it also slow up the process? And I suppose you and
Well,
your colleagues
I-
can stand accused.
No, I would love for someone to show me the statistics to prove that jury trials slow down the system. I
How long
don't
is it?
know
Okay.
where the statistics are, because
Okay.
I've heard from the Chief Justice in his address at the opening of the law term. He has lamented jury trials, and now this bill is also focusing on the aspect of jury trials. Where are the hardcore statistics to show that because of the jury, and this is my point, that because of the jury, your trial is slowed
Not
down
only because of the
or
jury,
delayed?
but the selection process and the rejections and and all that doesn't
Faziri,
that take a lot of time?
If that takes a week maximum in a major trial, that's plenty. You look at other systems, you look at in the US, sometimes, like for instance for the OJ trial, think of how long that process took for the selection. It took maybe about a week. But once you get past that, then you proceed with your trial. So I will never at all, unless someone can present the hardcore statistics to say, well, look, the jury system or the jurors are responsible for delaying the trial, then I will not accept that. I will not accept that at all.
Can it be argued that it is better for a trained attorney to manipulate a jury than they would a judge?
Well, the point is, it's not a matter of manipulating a jury. The question is, if it is that the jurors are the determinants of fact, then of course you are able to appeal to them. You know, in other words, if it is that a man has been accused of stealing avocados, you know, if you are the attorney addressing the jury, you will say, but the man thief too zaboka.
Right.
You know, so therefore you bring it down to the local parlance
So it's
so that
Mama
you
Gism
are
then.
able to relate to the jurors better because they see it from a different perspective. And I'll tell you, Fazil, that is something fundamental in our current system. And I am not sure that we should sit at this higher level and just legislate to remove that. If it is that
Andrew,
there's
if I
wider
can-
consultation
Yes,
on the
okay.
issue and you involve the public and the public says generally, well, look, yes, we are all in favor, then that's a different thing. But I have a bit of reservation, I must say, about this.
Why then would the Attorney General allude to 22 jurisdictions in the Commonwealth that have done away with the jury trial system?
Well, the point is there may be 22 jurisdictions in the Commonwealth that have done away with it, and it might work for them. But the point is, he's not in those jurisdictions. He's here in Trinidad and Tobago.
What makes
so
us so
we
unique?
must
Why-
face our realities in terms of what we are doing, and maybe statistically they were able to show that their jury system was a cause of delays, and we don't know if that's the reason why they did away with it, if you understand me.
Yes.
So you must compare apples with apples. It's not just a matter of pulling, because you could always pull numbers from anywhere to make a case.
Sure.
So I am saying, can we have the evidence to show, okay, in these 10 trials, if it were not for the jurors or the jury system, the time would have been cut down in half. Nobody has presented that type of evidence with the greatest of respect that we can compare empirical data. And that's my point. So in other words, if it's not, then it really is a knee-jerk reaction, an attempt to say, well, look, yes, we are doing something to speed up the system. You know, it's like, for instance, the proposal to say, well, look, let's decriminalize small amounts of marijuana to speed up the judicial system.
Yes.
With the greatest of respect, that's not speeding up the judicial system. All you are doing is trying to reduce the number of cases filed in court.
Yes.
But that is not affecting the speed of your system. So let's focus on the things that can speed up the system. Say, for instance, the good achievements, and this is what I always like to bring the positive.
Sure.
The criminal procedure rules, which are to be implemented very shortly. Those are things that you can do to speed up the system. I've also suggested for you, every judge, every magistrate ought to have an attorney at law assigned to them as a dedicated research assistant. I know they have judicial research assistants in the High Court, but the point is sometimes they are shared between judges. But I think in court, sitting there, you know, like the same way you have the usher and the clerk sitting, you should have a trained attorney who can be online researching things. So even while the trial is going on, the judge could just whisper a note to the attorney who is doing the research and say, look, check this point. In other words, even a submission that an attorney might be making. Because sometimes you see attorneys, they cite cases and there's no relevance at all to the case they cite, but they cite it with such authority and aplomb that, you know, it sounds good. So you could double check it. You could have, so these are things that would speed up the system, if you understand me. In the magistrate's court, as I've said repeatedly, remove all the police prosecutors, put attorneys to prosecute all the matters, because several times you have with those matters, police officers, they're faced with a legal submission and they're stumped. So they can't move forward. So therefore, they now have to ask for an adjournment. They then now have to refer that file to the court and process. Court and process then has to now refer that file to the DPP. The DPP then has to now find an attorney within his office to deal with that matter. When that attorney gets the file, he then has to go back to court and process, who then has to go back to the prosecutor to say, well, okay, what are the notes of evidence that may have been given? Because you can't just look at a legal point in isolation. You must have the context, the factual matrix. Yes. So therefore, you're talking about months and months and months. Now, if you had a trained attorney at law prosecuting that matter, he may be able to respond to the point immediately, or he may, within 2 days, say, well, look, Your Worship, I can come back, you know, in 2 days' time and answer this, and you move along. So these are the things we should be looking at if we are seriously talking about speeding up the digital system. And these things don't require legislative intervention. These are simple, practical things that can be done from tomorrow.
And you talk about being pompous but irrelevant with some of those pronouncements. It sounds like the parliament. But speaking about this and that, I don't know if you're taking exactly the side of the opposition, because from what we heard,
no, I'm not taking any side at all.
From Gerald Ramlin,
I'm not taking
he's
any
talking
side
about
at
it being a violation of your rights to a trial by jury. Do you concur with that view at all?
No, actually, in that case, I accept what the Attorney General says, in that there's no constitutionally enshrined right to a trial by jury, and the Attorney General is quite correct in that regard. So
But is it a violation of human rights in any way?
No, but I'll tell you where it impacts. It impacts upon the liberty of the subject. So I think that's the connection that you can make. So in other words, if it is that you are changing fundamentally your criminal justice system in a way that the liberty of the subject can be affected, so that person's freedom can be, you know, changed, you know, you could be detained, incarcerated, whatever, then I think in those circumstances, maybe the approach ought to be a more consultative and a more all-embracing approach, rather than you saying, look, whether the opposition agrees or not, I'm going ahead with it. So I think from that respect, I will say we ought to have much more dialogue on it. Maybe we ought to have, you know, much more public consultations on the issue, because it has the ability to impact the liberty of the subject.
As someone who is very much involved in the legal system, it is your profession, of course, and we'll touch on the issue with one of your clients, Farley Augustine, in a couple of minutes as well before we wrap up this morning. From your own perspective, are these cosmetic changes? Is there a more fundamental issue with the whole issue of the process of justice and justice being done in a timely manner from your perspective as an active practitioner?
I would think that there are much more fundamental issues that can be dealt with, and I think that this is not necessarily going to get the effect that is touted. In other words, I cannot see this speeding up a criminal trial, because, as you quite rightly pointed out, and you've made the point several times, sometimes the attorneys are responsible for the delays because they seek adjournments. You may have one attorney having 5 different cases in one court at the same time. So therefore he's saying, look, could I have an adjournment here because I have to deal with another matter, that kind of thing. So these are some of the things that create the problems. So I am not sure necessarily that this is going to be the cure-all or the magic silver bullet that it's touted to be.
Are practitioners within the system, not just the lawyers, not just the other legal people, the judges and so on, are practitioners within the system, from your own sense, happy to continue with things as they are? Or are they resistant to any sort of initiatives and to create a more effective system of justice?
Well, the thing is, the nature of human beings is such that we are often resistant to change, because the thing is, once you get in a comfort zone, it's, you know, always difficult to nudge you out of that. For instance, when the civil proceedings rules were initially introduced, right, the 1998 CPR, you know, lots of practitioners were up in arms against it. They said, you know, this is not good, you know, it's it's going to destroy your practice. You know, lots of things were said. But it has been working fairly effectively, and of course with some tweaking it can be improved. And for instance, the family court, there was resistance to that, and that has been working wonderfully well. And I assume similarly with the criminal proceedings rules, which are due to come on stream, you will get some resistance initially, but I think eventually you can see some benefits there. So that's why I say we must always give credit where credit is due. So in other words, the good initiatives that are working, yes, we have to look at those, refine those, praise those. But the thing is, we must always be careful not to just go on a knee-jerk reaction and say, well, look, trial by jury is the problem, without the statistical underpinning to justify that claim.
You might try your best to sound balanced, Mr. George, but you'll get cussed no matter what you say on social media or anywhere else. But as we're talking about the different issues, and before time evades us completely for a segment this morning, your client, Farley Augustine, from the THA elections, it is being suggested that he is in violation of the law by having 2 THA jobs, as a teacher and now as an assemblyman in the THA. That we were following some of that in the news yesterday as well. Just give us the perspective as you see your client's position.
Well, we've called upon the administrator of the Division of Education, Youth Affairs, and I think they've now added innovation and energy to it. So it's an expanding division within the THA. But we've called upon the administrator to point us to which legislation it is alleged that he is in breach of. Once they can do that, then we can analyze it and assess it and then make a rational decision. But what they've done instead, he's worked for the month of February. They've not paid him for February. They've paid other educators. And, so he's wondering, well, has he been singled out even though he has worked for the month? Any time that he has, been to the assembly for his duties as an assemblyman, he has applied for the time off. He's been granted the time off. So therefore, he's asking, what am I in violation of? Why am I being singled out? And he's also cited other examples of persons who have previously been employed with the THA and also who held official posts, and nothing was said.
Official salaried posts?
Official salaried posts, yes. And nothing was said or done in relation to them. So therefore, there's a question of equality of treatment under the Constitution, and of course the principles of fairness and natural justice. In other words, it can't be one law for one and another law for another, side. So therefore, we are simply asking the question, and we are hoping that she would provide the responses, because we are saying if there's no logical basis, then you fall into the realm of Wensbury unreasonableness, because that is a principle in law whereby if you cannot justify logically or reasonably why you have taken a decision, then if someone makes an application to the courts for judicial review, the court is entitled to make a finding that your action was wrong.
And just so we could understand, as far as the legal process, what is there to be a hearing on the matter or a ruling?
Well, we have to await her response,
right,
because we have given her the opportunity. We always are very polite, and we give you the fullest opportunity to explain yourself, explain your actions, justify it, point us to the law. Maybe it might be that you do have a relevant article or statute that you can point us to and say, well, look, and then if we look at it and we accept it, we will say so. But the point is, it cannot just be a knee-jerk reaction where you are just calling upon him arbitrarily and capriciously. And I'll tell you, he did the right thing all along. Even before he went for elections, he wrote to the administrator and said, listen, I am considering contesting, I'm going to be offering myself. So all of this was made clear from the get-go. I think upon winning, maybe the dynamic has changed and some decision was taken that, look, they need to deal with it. And we are saying, okay, if you are doing so, do it within the ambit of the law and show us on which legal statute or provision you are hinging your decision.
Martin George, proper and polite before burying his legal feet, depending on how things go. Thanks very much for joining us, as always. Attorney at law Martin George, giving us a perspective both on the issue of trial without jury, with just the judge presiding, different perspectives on that, and also the matter involving one of his many clients, Farley Augustine, in relation to this matter of whether or not he is in violation of any statute or law as to the question of both being a teacher and also an assemblyman in the Tobago House of Assembly. 6:40 in Trinidad and Tobago. We are in the first hour of Morning Edition on this Wednesday. We'll be right back.